Hello, everyone. It's Anthony Bandier here, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you another Search and Seizure show. This is going to be streaming. It's streaming live right now. We have some people online that are going to ask some questions. We also have some questions that have been sent to us around the nation. I'm with my good friend, Zach. Zach, introduce yourself, please.
Hey, Zach Miller, one of the legal instructors here at Blue to Gold. 19-year law enforcement career, retired, full-time legal instructor.
And you're broadcasting from Virginia. I'm broadcasting from, I'm not going to lie to you, Zach. I'm actually kind of in a crappy room in Pierre, South Dakota. They
Yeah,
don't have a lot of options. Have you been to Pierre?
I haven't been to Pierre, but I've been to several other cities in
Rapid.
South and North Dakota, and all I can ever find is a Best Western
Yeah, I'm
or
not.
a Wyndham, a Wyndham.
Okay,
Yeah,
I'm in a Wyndham. Okay, that's
Wyndham.
where I'm in a
Yeah,
Wyndham. And
yeah.
it's
They're not that
I
great.
know. If I didn't love what I did so much, I would be a little more upset. But I do it for the peeps, right?
Yeah,
Uh,
that's right.
but I did talk to our cops at the class today because I'm teaching at the state law enforcement training center, which South Dakota is like all centralized, right? It's such a small state that they just really train in one spot, right? And they gave me some good advice for the next time I come to not stay at the Wyndham. There's a better place, which I did not know. So
Oh,
there's
okay.
there's no Hiltons, no Hilton. You're a Hilton guy too, right,
I
Zach?
am. Yeah, I try to stay at Hilton's.
Yeah, me too. Rick said that room has style. Okay, so here's where we're at. We're going to answer some questions, and so that's, Sean says there's nice turn down service. I think we want to turn up things around here, not turn down things. I want to cover things up, Sean. I don't want to cover things down. So let me see. All right, so let's does anybody, so first of all, this is how this works. Let's do some rules of engagement. We do have a lot of good questions that I want to answer on email. But for those who are live here, if you have a question and you want to ask it live, all you got to have is a microphone, no camera. You're just going to see us. But if you have a question, you just want to ask us and get our feedback, that's what this show is all about. Until you guys figure out you have a question, I'll just say me, I have a question. That's all you got to do on the chat. But in the meantime, let me start asking some questions because there are actually some really good ones here. And I do want to kind of get through all 5 questions, okay? And so let's kind of get down to business, if you know what I mean. All right. So this question is, did you see some of these questions that I sent? Did you actually look up some of these?
Yeah, I did look at them. Yeah, they're
Okay.
they're
So
they're good ones. They're the good
they
ones.
are good ones. Okay, they are good ones.
Yeah.
So the first one I want to talk about is the one from the officer in LA, right? He's LA Sheriff's Department. And he says, look, LA County has went to a completely like no bail, zero bail for most misdemeanors and some nonviolent felonies, okay? If not all misdemeanors, I guess. Well, many misdemeanors. And so, vandalism, shoplifting and trespassing. And so you can't arrest these guys. You're going to have to, the cop is going to have to cite and release on scene.
Mhm.
Um, Now, California has something that's called the stale misdemeanor rule, okay? And they're wondering, including their local attorney, is how does this stale misdemeanor rule apply in a situation where we go to a business and we see evidence of shoplifting, right? We see John Doe clear as day on the camera stuffing his backpack full of merchandise. The loss prevention is not able to get him that day, but then the cop sees that guy. Let's say it's like a homeless person, right? They see
Mhm.
that guy 3 days later, walk on the street. The cop clearly has probable cause that he was the shoplifter 3 days ago. Um, does this stale misdemeanor rule affect giving this guy a citation? And let me, I didn't, do you know have you heard of the stale misdemeanor rule? Are you familiar with that?
I I'm I don't really understand what it means. I don't
Yeah.
staleness. I understand staleness as to searching,
Yeah.
but I
So
don't
let me,
understand. I don't,
and by the way, I got to tell you, it's a California thing.
yeah.
So there's some case law that says that, and they kind of try to pin it on some colonial, common law stuff, which I
Hmm.
don't think is, I don't think so. But the point is they have this idea that if you are pursuing a misdemeanor, right, and you want to make an arrest, this is why it's important, by the way. I think this is why this gives us our answer. But if you're pursuing a misdemeanor, let's say you see a misdemeanor committed in your presence, right,
Hmm.
and you don't decide to stop the person. You just kind of like, you keep it, you check it in your head, like, okay, that person committed a misdemeanor, and you go do something else, like you go to lunch, right? and then you come back later and find the same guy and then you arrest him. California would say that that's a stale misdemeanor. In other words, that the intent of arresting people for misdemeanors in during the common law was to handle like a public nuisance, right? Like a breach of the
Yeah.
peace type stuff, right?
Right.
So if you're just going to let it go and you're not going to take enforcement action now, and you didn't, and you unnecessarily did not take enforcement action, it becomes stale. But here's the key, Zach. At least to say the least, even if it is valid as a doctrine, you couldn't arrest in California. The stale misdemeanor does not apply to citations. So
Okay.
now let me just kind of read something to you real quick. This is actually let me share my screen real quick just to kind of give people some context here. I have something on this. So this is just a screenshot that I took. Do you remember when they did the Alameda County did the point of
The
view,
DA, yeah.
which is the best search and seizure document, or education documents and that exist. I love them. Nobody writes better than this guy, and I forget his name. And I wish I if you said it, I would know his name. But so it says here, still misdemeanor. Even though a misdemeanor was committed in the officer's presence, there is a long-standing rule that they may not arrest the suspect if they delay doing so for an unreasonably long period of time, right? This essentially means that the officers must make the arrest before doing other things that did not appear to be urgent. As the court explained in Jackson, the officer must act promptly in making the arrest and soon as possible under the circumstances and before he transacts other business. It's a misdemeanor, take care of business. Now, the author, which I love this, right? He says note that because this rule is not based on the Fourth Amendment, a violation cannot result in the suppression of evidence. Still, a lengthy delay should be considered by officers in determining whether the subject should be cited and released. Okay, so there's your answer.
Yep.
So there is no law that I'm aware of, constitutionally or otherwise, that says that even if we first of all, I don't even think the still misdemeanor rule applies here anyway. Well, it doesn't apply because the cop did not have the guy in his presence anyway. It wasn't like he was doing other things. He happened to see the guy 3 days later. But regardless, when they stop him 3 days later, they're only issuing him a citation. That is not an arrest. And and even though it's not committed in the officer's presence, it's still not an arrest. It's not forbidden by California law. What do you think about that? What's your answer? What's your feeling on that?
First of all, I think his name is Phillips, isn't it? Robert.
The cop?
No, the attorney. He's retired now. The guy.
No,
from
it's not Phillips. Robert Phillips does legalupdates.com.
Okay.
It's not Phillips that wrote Point of View.
Okay.
Yeah.
So the stale misdemeanor, it precludes a warrantless arrest, or you can just never be charged for it if you don't get arrested promptly. That just doesn't make sense. I mean,
It's a stupid rule. And again,
yeah.
only California they even talk about it. But it just basically says that if you don't take care of business, like if you don't pursue that misdemeanor committed in your presence, basically, diligently, then you cannot make an arrest. But you can cite.
Right. And that obviously isn't, that's obviously not a Fourth Amendment rule. And California, as you know, when it comes to criminal law, has to follow the Fourth Amendment.
Yep.
So yeah, and there's no arrest here, so that's a non-issue.
That's that's my answer. So my officer in California, if you're watching this, share that point of view with your prosecutor. We don't believe, that this even is an issue. Just issue him a citation. It does not violate state or case law. He can be cited, right? As long as you are within the statute of limitations. Okay. Well, that's probably a different issue anyway, right? Okay. So the next question comes from an officer in Fresno, and so Patrick, can you come on hold on? If he's unidentified, you could stop an ID, but cannot arrest. Otherwise, you could submit your. So Patrick is saying if he is unidentified, which let's just say that we know him or not know him, but you could stop an ID, but you cannot arrest. Okay, fine. Otherwise, you could submit your case to the DA to submit an arrest warrant or cite and release. Yeah. But but a lot of, I can just tell you right now, this would be the same result in a lot of states, because in a lot of states you couldn't arrest this guy anyway.
Correct.
It
without a
wasn't
warrant.
in the officer's presence,
Right.
unless you had a citizen's arrest, which may or may not be, you know, it may not be actually practical to arrest somebody 3 days later under a citizen's arrest anyway. So anyway, it's probably, it's probably irrelevant. Okay. So either way, just cite him. He gets cited, I believe. I don't think you have to submit anything on him. That's a lot of work for a shoplifting case.
Yeah.
All right, the next case comes from an officer in Fresno, California. He says, so we were dispatched to a physical disturbance in the middle of the street. An officer, was basically, we were like, the cop was wrapping up some other issue, and a citizen came up and says, hey, there are people, like there's a domestic basically, there's a male and a female fighting around the corner. So the cop, kind of runs over to the corner to see what the hell's going on, and he sees this male try and take a swing at a female. Okay, swing at a female in the middle of the street. I guess they didn't land any blows, but it's definitely trying, right? Now, the male and the female see the police and they run into the house. Okay. So now the garage door, they ran into the garage is in the kitchen and so forth. So the partner basically they talk to the female, and what do they do here? She's drunk and uncooperative, right? Semi uncooperative. And it took her several minutes to get her to come out of the house. Once she came out, they developed probable cause for a felony about 10 or 15 minutes later that he committed a felony on her. Okay. Now, really, this is where the story needs to end, because the question for us is, with those facts, could the officer then go into the house and arrest him under hot pursuit? That's what the question.
10 or 15 minutes later?
Yes.
No, I don't see. It has to be a continuous pursuit.
Yeah.
So yeah, no, not without an exigent, not without some other exigent circumstance. Yeah.
Yeah, and the thing is, not only is it not continuous, but it was never hot pursuit, right? I mean, I don't. They never they never chasing the guy. I mean, I guess you could look if they chased him or they were trying to chase him, and they were like, "Look, we're not going." I mean, I guess they have PC for something, right, Zach? I mean, if you're swinging your fist at a female, you have PC for something, right?
Yeah, yeah.
At least disorderly conduct. Okay, so fine. You got the PC, and you say, stop. The chase has to start outside the home, right?
Correct.
And we also know that if you start chasing this guy, you don't have to just run. If you do have valid hot pursuit that starts outside the home and they go inside the home, there is definitely plenty of California cases that have held that you don't have to chase them blindly into their home in order to get ambushed and killed, right? You can actually wait for the resources. So here that's not even what's happening anyway. They're actually just investigating. So I don't think they ever really had to me, I don't think a pursuit ever occurred here. But the other thing, we have a Lang versus California problem, don't we? Because even if he was swinging at the female, that would not be a felony with those facts. We do not know at this point that he committed a felony. What we see and what we know is a misdemeanor, right? It seems like a disorderly conduct issue or an attempted battery, right?
Right.
So that's going to be a misdemeanor. So tell us about Lang. What's the training point there that the cops should know?
Yeah, Lang. I mean, just chasing someone in a hot pursuit to make an arrest for a misdemeanor by itself is not justification to enter a residence. You need the misdemeanor plus at least one other exigency factor, which such as you think he might obtain a weapon or there's somebody else inside that he could harm or destroy evidence or something like that. So just there has to be some additional exigency factor, and I don't know that that's necessarily not true for felonies either. I mean,
I'm glad you brought that up, Zach. I think that they get qualified immunity at this point. So, it's nice to ride out the wave and be like, but I've been teaching these cops and I really should update my slide deck because I talk about this and, I put felony in there as a reason to pursue. And we really just need to change that and be like, exigency. I mean, felony with exigency, because even Santana is an exigency case, right? Even Santana, where they chased her into her home. And, the court did say it's a felony, but they also said that she could destroy drugs, right?
Yeah.
So, because Santana was a drug dealer. And I think it's, foolish to read 40, 50 years of case law involving the Supreme Court and the way they treat homes, and to say that any felony will allow you to chase somebody to home, because in many states, bouncing a check for over a certain
Right,
amount is a felony.
right,
And I
right.
do not think the Supreme Court is going to allow you to chase people into their homes over a bounce check.
Securities fraud. I mean,
Yeah,
I mean,
seriously. Right,
right.
right.
Yeah, yeah,
Right. All these, having a 10-round magazine, or no, 11-round magazine in the Republic of California,
right. Yeah.
So, it's like, okay, let's just be real here. Like, when we say felony, like we're civil rights, constitutionalists. So, like, when we say felony, we think about the old school days where people could lose their head. Now,
Dangerous felonies.
uh, people can get a felony for all kinds of stuff, right? That's a little
Yeah.
overkill. Okay, so that's the first thing. So I don't think a hot pursuit ever occurred here,
Right.
and B, this would not be a hot pursuit. Even with a felony, you just can't go into the guy's house on a felony alone. However, what if she was, I mean, it does help when they're more cooperative, but let's say that he wailed on her, she moves her hair back and she has this big bruise on her face. She was beat to hell, all this kind of stuff. And she's outside the home. What do you think about them going in the home? Just with these basic facts, Zach. What do you think that them going to the home and just using agency to get him in custody, like right now? Or would you want them to just wait outside and go get a warrant?
Still would need some reason to believe there will still need exigency. I mean, or consent from her.
Yeah.
But absent some belief there's someone else inside that he
What if she
could be
says,
harming.
what she says, but sir, I want to, let's say she's more cooperative. Okay. Like, let's say,
Mhm.
look, yeah, he beat the hell out of me. I just want to go home. I got to rest. I just want to go inside my home. I'm going inside my home. What do you think? Do you go in and you're her guardian angel, or do you think the law would require that she's just,
If
because you
she's
can't stop
outside,
her. She's outside the home, but she can go inside her home, right? You can't stop her.
no, no, right, right.
So, but she wants to go inside her home, but she's also saying to you, Officer Miller, with your beautiful eyes, can you please save and help me and protect me? I need to get some sleep. I'm really tired and you really beat the shit out of me. Can you
Mhm.
please come with me and help me get him and take him with you, and so I can go back in my home and have some peace? Miller,
Yeah, and
where?
she's consenting to me going inside.
Oh, I see. Well, what
Yeah.
if he says, okay, fine, I'll take the consent out of there too. What if he
Okay.
says, don't come in the house?
Okay, so we're at Randolph now.
Yeah.
I don't see how we can go in with where's our exigency, you know?
I
Um,
look, I
but
I'll tell
is a court gonna, reality versus what the law actually says is two different
yeah,
things in some
it
cases.
is.
So
It
is a
is. It is.
trial court judge gonna suppress this? Probably not.
Nah.
No.
Look, my feeling on this, and I'm trying to find a case on this in the meantime, but it's
Mhm.
like, what a very tough situation to put a police officer in.
Yeah.
And what a tough situation to put her in. And I mean, is it really fair and reasonable? Is there no sense of urgency that this poor woman, victim, man, whoever it's going to be, right? That this person just wants to go into a place they're lawfully allowed to be and be safe without being beat up? Do they really have to wait outside for 2 to 3 hours, depending on in the snow, in the cold? Or maybe that adds to agency, but you know,
Yeah. I
but
see where you're going with this.
yeah, but I mean, is it really fair? I mean, is that reasonable that we can't just take this guy in custody because she wants to return to the very place that she's allowed to be and not
Mhm.
be, I don't know. I have always felt that you know there's some urgency here,
Well, hold on. So here you go. Here's one distinction. So Randolph, the no, him saying no, her saying yes, that applies to the search of the home for evidence. There's a distinction between entry and search, and they talk about this in Randolph. They talk
I
about it in the oral argument. They talk
yeah,
about it in the case. I think in one of maybe the concurring opinions,
yeah.
because that was a concern. Was it? I believe it was Breyer who wrote a concurring opinion because
Mhm.
his concern was domestic violence investigations,
Yes. And but
where if she says come in and he says stay out, that's not the same thing as the Randolph case. Hers is come in and go search our bedroom for evidence.
Yeah, but we're
It's
talking about, but we have agency there. I mean, at least you can read between the lines on that. Like clearly, even if you don't deal with that as a consent issue, he can't keep the police out when they're trying to. And this is why I'm saying this is legit because
yeah,
they are
I think
trying
it
to
is.
handle.
Yeah, I'm walking back my position. I think
Yeah,
we can.
good. Because,
Yeah,
but
yeah.
but you do agree though, if I'm in my house and the cops come into my house and my wife let them in, right? And I say, what are you guys doing here? And they're saying, hey, we're just talking to your wife about some incident that happened last week, you know? And I say, well, get the hell out, right?
You gotta
And they
go.
say, no, we're not leaving because we're not searching. We're
Mhm.
just talking to your wife and we're here. We're not searching. Randolph says we're not searching. And so we're gonna be here. And I say, no, I told you, get out of my house. Did they have to leave? Yes or no?
You gotta go. Yeah, you have to leave there. You have to leave
Even
there.
though they're not searching.
Yes.
Yeah, good.
I think the not searching, just being there, I think only applies in a domestic type of a situation. There is an underlying type of exigency, but it's not
Good.
that like somebody's going to get killed if we don't do it now type
I
of.
I agree. I agree. I think we're on the same page. In fact, I'm glad you brought up that those footnotes and some of that just because I remember them talking about the agency. I'm sorry, the domestic issue, but I
Yeah,
always just read into it as some form of urgency. You know.
yeah, yeah.
All right.
Same page.
Sean, don't bring politics into this, okay? So, all right, that was a dumb joke, but I tried. All right, so the next one, that's a good one. Okay, so these are good. These are really good. All right. Um, okay, good. So the next one is from a cop in Texas. Okay, the great state of Texas. My department has been has having a lot of success using software like Clearview AI and arrest.org to identify suspects. So basically what they're doing here is that they're just putting pictures of people through the software and they're just identifying them through public records, social media pics and booking photos and so forth. Obviously, very common, right? That's why these softwares exist. Now, the question though, which is really good, is the cops want to identify, you know, they want to identify the passenger, right? And the passenger won't provide ID. Well, again, they don't have to provide ID if they've done nothing wrong. There's no crime in being with a driver who drives too fast, right? So they want to take his picture. Let's answer the first question. If they snap his picture without his consent, they just, kind of do the whole, yeah, yeah. So you're a Red Sox fan, huh?
Right. Yep.
Yep. So what do you think about that? And then they go back to their phone and they upload that to their app and they identify him and he has a warrant or something like that. What do you think about the idea about taking his picture just as a matter of routine?
As a search and seizure matter, it's a
Correct.
non-issue.
Search and seizure. Yep.
It's not a search and seizure. It's not a search. It's not a seizure.
Why is it? Why not? Why is that a search?
Because you have no reasonable expectation of privacy in your identity, particularly when you're out in a public area. I mean, you talk about all these cameras that capture your face as you walk through, public areas. There is no reasonable expectation of privacy,
Okay.
at least as the Fourth Amendment contemplates. So this would be more something that would be addressed by a legislature.
Yeah,
Um,
like facial recognition laws, right?
yes, not this is not. It's not a Fourth Amendment issue. At least I don't see it that way at all.
No, it's not. I mean, it's the same. It's just like you said. I mean, the court has made very clear that, well, they said that your voice is not private. They said
Right.
that your fingerprints aren't private. I mean, I'm not saying you can, force people to, put their hand on your fingerprint scanner just as a matter of routine and they didn't do anything wrong. But that brings us to the next question, which is, what if the passenger sees what you're doing? They go like this.
Yeah, then you can't forcibly move his hands because that's a seizure then when you do that because you're applying force. So that does require justification. So that's the physical application
I
of
say you hit
force.
them with obstruction. You're obstructing my investigation.
Right. But
You're
if I don't have
obstructing.
reasonable suspicion
Yeah.
towards it, no, yeah.
You're obstructing my attempt to make a
Right.
search does not fall under the Fourth Amendment. That's what I would say.
Exactly. Yeah. Yeah. So your remedy is put your hands over your face. You don't want your picture taken. Yeah. Yeah.
Right.
That's a
It's
non-issue.
like, isn't it true? It's like it's the same thing as like, okay, yeah, you don't have any expectation of privacy in your fingerprints, but if you put gloves on your hands, then You know,
Right, right.
all right. I did like what you said though. It's a legislature issue, right? The legislature can control how police use people's facial recognition. That is a concern. There are some states that have passed facial recognition laws, just like they passed other laws involving drones and so forth, to kind of temper the intrusion of a technology. But constitutionally, it's a non-issue.
Yep.
What if the body cams get to the level of face recognition? So it's the same thing.
Same thing. Yeah.
Um,
Same.
and that's just that there is going to be a day when there's going to be states that definitely are going to pass law. And I know, and first of all, there are already some states that pass laws on this
Yeah.
where you cannot do mass facial recognition. You could not, I mean, well, New York, I think, does it on Times Square, but they just do massive facial recognition, right?
Yeah.
But some states are concerned about privacy, right?
Right.
And they would prohibit mass facial recognition in public spaces.
Yeah. All invasions of what we might call privacy in the general sense of the word don't necessarily implicate the Fourth Amendment. Like these aren't all constitutional issues. Some of them are legislative issues, and this clearly is one.
Yeah, political, legislative. Yep.
Yeah. Right.
Just hopefully the government uses good discretion. Right.
Sure. Right.
Okay. Uh, all right. Okay. So, and also, guys, we need. I want who's. I need somebody to ask the question because this is a really good conversation. But let's see. Is Emmanuel here? Emmanuel's not here today. Our boy Emmanuel. Does anybody else have a question? Just please. All you gotta do is turn the mic. Just ask your question. What's your search and seizure question? And let's see if we can answer it. Okay. All right. So this officer is from Nevada, and he says this is an NRS question, Nevada revised statute question, but I can help answer it. So it says, under what circumstances can a jail place a 12-hour hold on a person? So in Nevada, if a person gets arrested for DUI, whether boating DUI or vehicle DUI,
Mhm.
and they are intoxicated, like I'm sorry, they're with alcohol, they cannot be released until they blow a point. Hold on, let me see. I have the NRS right here. It's 0.04. Okay, so NRS, so it's NRS 178484. Let me just kind of show you real quick. So it says it right here that a person arrested for a violation of these NRSs, this is your DUI cars and DUI boats,
Okay.
who is under the influence of intoxicating liquor must not be admitted to bail or released on the person's own recognizance if he has a concentration of 0.04 before he has a 0.04 in his or less, right?
Okay.
Then it says a person arrested for the same crimes, right? DUI, who is under the influence of a controlled substance, must not be released sooner than 12 hours after the arrest. So it's from the moment of arrest. So if you get arrested at midnight, it's noon, right?
All right.
Not from the booking. I think we understand why these laws exist. This is just so that the person there was a case, Zach, in Nevada where somebody got into their car, and killed somebody, right? It happens everywhere, right? They got arrested for DUI, they got released. The guy ended up getting his car out of the tow impound lot, whatever, and drove drunk again and killed somebody. So that's why that law exists. Is just hopefully you have maybe a better successful outcome that the person doesn't drive again.
Mhm.
So the officer is saying, but here's the deal. Here's the twist. Okay, in their jail, if the guy is arrested for, let's say, shoplifting or possession of a stolen car, well, that's a bad example. If the guy is arrested for some kind of pedestrian crime, let's say malicious destruction of property, okay,
Yeah.
and he tells the intake booking officer that he has actually consumed drugs recently, they put a 12-hour hold on him. But he's not drunk. I'm sorry, he's not DUI,
Mhm.
and he's not a boating DUI. So the question is, how's that lawful? I mean, it's not, right? It's
It's the,
not per this law.
yeah, the statute's pretty straightforward as to what the
Yeah.
predicate offense are, and that's not one of them.
Yeah. And the cop
Um,
says, is this a violation of, is this a Fourth Amendment violation? That's a whole different question. Does the Fourth Amendment Probably not. I don't know. I mean,
That's probably a due process, maybe
yeah,
violation.
yeah, maybe right. Okay, there you
Yeah,
go. It's not
yeah,
necessarily a Fourth Amendment issue, a search or seizure issue. You've been lawfully seized.
yeah.
But it's a due process thing. The law is saying that you're not supposed to be in jail for in Nevada, we do have, a bail schedule and a bail, matrix and so forth. And
Okay.
he probably had the right to get out of, if everything else is fine, right? He would
Yeah.
have the right to get out of jail after 2 hours or so. I'm making this all up. But
Mhm.
yet he's in jail for another 10 hours. That's 10 hours of his life that he wasn't supposed to be in a jail per the law.
Yeah.
And all I can say is I think the hearts are in the right place. I think these officers in this agency are just trying to make sure, they're trying to, maybe they're just they're trying to act like in the spirit of law that people are intoxicated.
Mhm.
But I think that's a bad practice. The law is the law. Unless we're missing something here, we're just reading what we have. Unless there's something else out there that says that they can be held because they consume drugs and they can be held for another 12 hours, which I'm not aware of as a Nevada police officer. Um, I think the guy should be released.
Yeah.
List the law. If you don't like it, go to the legislature and ask for an
Change
expansion
it.
of that
Yeah.
law.
Change the statute.
Change the statute. Okay, so um, and you can get sued. And by the way, just so you know, Nevada at the state level has no qualified immunity.
Ooh, okay.
Yep.
Right.
So if they found it to be a violation of due process, the Fourth Amendment, well, due process is a little tough because I'm not sure Nevada what their due process constitutional provision looks like if it's similar to the feds, because the feds obviously have qualified immunity. But the point is, it's problematic. It's not a good practice to violate people's rights and violate the law. Okay, so this question comes from another officer in Nevada. He comes from Winnemucca. You ever heard of Winnemucca?
Never heard of it.
So Winnemucca is, maybe a little bit more than halfway between Elko and Reno, and it's affectionately known as the Muck. Small cowboy town, whatever you picture in your brain, that's what it
Mhm.
looks like. So, um, this, so the question is, what are some of the things to consider in regard to searching a stolen vehicle with the owner's consent? The officer said we had a vehicle reported stolen. The reporting party stated that he believed that the vehicle was stolen by a family member, his son. Later in the shift, an officer located the vehicle, which was occupied by the suspect, so the son, right?
Mhm.
The reporting party arrived on scene to reclaim the vehicle and also gave the officers consent to search the vehicle. Now, I got to tell you, this is probably a little bit of a softball question, right? Because
Yeah.
it seems kind of obvious that we can search the car under these facts. But why don't you answer that first question, right? Do you see any issues here? Just making sure, can we search the vehicle with the owner's consent? And if so, what can we search? Is there anything that's going to be off limits potentially?
Yeah, we can. He obviously can give consent. Anything that might be potentially off limits would be maybe if the son has exclusive property in there inside the
Like
vehicle,
a
maybe a
backpack or
backpack.
something?
Yeah, yeah.
Okay.
But other than that, the everywhere in the vehicle itself, the owner can give us consent.
Yeah.
Absolutely. It's his
Yeah.
car.
Yeah. It's his car. And we should be asking for consent, right?
Yeah, sure,
Mm.
absolutely. Yeah.
Yeah. I mean, what if the son put drugs in there and maybe the son has a firearm in there
Right.
we want to kind of clean the car out, right? And actually there is a
Yeah.
case out there where the police, before returning the car to the owner, they still search it, even without consent, right? They
Mhm.
search it to make sure that the thief did not leave, evidence behind and contraband behind, and just and also to build evidence against the thief, right?
Mhm.
Maybe their a shaved key is under the seat or whatever, right? And the court upheld it. And I think that's the right answer. I really do. I think that when you recover a car, I think the motor vehicle exception would just kind of cover that, right? Is there a fair probability that evidence of indicia of control and and so forth? Also, there was some also community caretaking going on there because
So yeah,
people that
same
steal
thing. Yeah.
cars do leave shit in the car. They like to leave their needles in the car and so forth.
Mhm.
So now I bring up the case because probably the owner got charged. That's probably what happened. Because
Yeah.
why would we have the case? I haven't looked at it in a while, but why would we have that case if the owner did not get charged and only the thief got charged, right? The thief has no standing anyway. That's what it is. The thief, why would we even talking about this, right? So the thief has no standing to contest the search of a stolen car. The owner must have got charged. So they must have found drugs or something against the owner and charged him or her accordingly. And they were challenging the search and the court upheld it.
Is Nevada one of those automatic standing states for
No,
possessory crimes? Okay,
no,
so it's, yes,
no,
you're right. So the thief has no.
no,
Yeah,
definitely.
the dad must have gotten charged or something, or maybe decided
Yeah.
to sue the police later on. I don't know. Yeah.
Yeah, just something like that. Can you I'm gonna look up for that case real quick, but can you explain what you mean by automatic standing to our viewers?
Yeah, so in some, for Fourth Amendment, pure Fourth Amendment purposes, you have to have what's called standing to challenge the search. And what that means is you have to have you had your Fourth Amendment rights violated. The search had to be of your property or your an area where you have an expectation of privacy. If I'm in a stolen vehicle, it's not my vehicle. I can't rightfully claim a reasonable expectation of privacy in a place I'm not allowed to be. I don't have standing under the Fourth Amendment, as the Fourth Amendment uses that term, to search the vehicle. So whether it was a illegal search or not, at the end of the day, really doesn't matter as far as the admissibility of evidence to the defendant. Some states have what's called automatic standing as for purposes of search and seizure law when it comes to possessory crimes. So possession of a stolen vehicle. In order to claim standing, you have to claim, or in order to claim standing, you have to claim an interest in the vehicle, and therefore you have to, you know, admit you possess the vehicle. So it's kind of a catch-22 situation. So when it comes to possessory crimes like narcotics possession, stolen property, states have what's called automatic standing, where the person doesn't have to show they had an expectation of privacy in the area, because that could potentially um, require them to admit that they possessed the item, which is an element of the offense. There's only
Yeah.
a handful of states have it.
Yeah. So what states have it? Do you know? Do you
I know
remember?
New Jersey has it. Off the top of my
What's the
head,
other
I
state?
don't know.
Is it New Mexico?
I
I don't know.
wouldn't.
It's probably like the couple. It's probably like Washington, New Mexico, and like New Jersey is the
The
culpable.
typical rogues gallery of
Totally,
states. Yeah.
Yeah, yeah. Um, so I did find that case. It's a district court case about inventorying the vehicle. It's actually out of Nevada, which it's and it's they upheld it under community caretaking, like basically part of their inventory. Like even though they weren't even like they weren't going to tow the car, it was a standard procedure for that agency to routinely inventory stolen cars, even before giving them back to their owner. They actually have a policy that they try to give, they wait up to a half an hour to try to get the owner of the car to come on scene so they don't have to tow it.
Mhm.
But regardless, they'll still inventory it. And they found it was lawful.
Okay.
Okay, so just for community caretaking, just make sure. And there was a gun in the car, and so it makes sense. I mean, that's why we do stuff like that. We don't want innocent person going down the road with a damn gun in the car, that's stolen and so forth.
Right. Right.
Okay, so those are the questions. It always feels good to kind of get through those questions because we get a lot of them. I might have, since we have a little bit of time on our hands and nobody's asking any questions at this point, no mic on MDT. So let's, Brandon or Zach, can you read that while I look for another question?
Yep. Let's see. If you want a curtilage issue, can officers enter the side rear yard to secure them in the event the suspect? Okay, so I assume we're out there, maybe serving a warrant. Can we enter the side rear yard to secure them in the event the suspect runs out the back when you're attempting it to serve an arrest warrant at an address? No RS, they're home. Just going down the warrant list, attempting to serve them. Obviously, we go to the front door and knock. But what about the officers, the backup officers? So I'm assuming we are at where we believe the suspect to live. And I don't know. I've always struggled with this one. It's a legitimate purpose.
Can you rephrase the question for me, Zach? For some reason,
So
it just kind of didn't register in my brain.
so we've got an arrest warrant. It's just one we pulled out of the basket. We're just going down serving warrants, and we go to a house. No reason to believe the suspect's there. Um, can basically set up a perimeter around the
Oh,
house
yeah.
to make sure in case he is there, if he runs out the back or hops out of a window.
I'll tell you what I teach, Zach.
Go
No,
ahead.
I teach no. I teach
Yeah.
no. I teach no because, and the reason I teach, and you tell me if you agree with me, is that I teach that you need three things to serve that arrest warrant. You need a valid arrest warrant, right? Good faith.
Yeah.
You need I do teach probable cause that is their home. Okay. I know we have the reason to believe language, but I think that ultimately, if the question was on the Supreme Court's desk and they were asked, do you need some probable cause or reasonable suspicion that this is their home? I think it's probable cause because you're dealing with the home, and we don't really messing around people's homes. I think that's the level of proof you need that this is their residence. Then I say, you need reason to believe, which is reasonable suspicion, they are currently home. So I believe you need a lower standard. That's just the way I teach it. That's the way it makes sense in my brain. I think it's good case law. Even though now our courts agree, that.
Mhm.
I think you need reason to believe that they're home before you. I know you need a reason to believe that they're home before you effectuate and you serve the warrant, right? We know that. That's from Payton.
To enter,
Well,
to
to
enter the home.
enter,
Yes.
correct. But we also know from Hardinus that the curtilage is treated like the home itself. So how
Mhm.
can I tell cops that they can enter the curtilage, the backyard, which is like the home,
Mhm.
without the proper authority first?
Yes.
So that's how I know I know curtilage is not the same as a home. It's not like being in their kitchen, but
Mhm.
it's close enough for government work. So I can't teach my cops, and that's the way I look at it. I can't teach you to go into people's backyard without the lawful authority first. And that means you need the reason to believe that they're home. Now, just so we know, we have a lot of California cops on tonight. In California, it's probable cause for both. Probable
Mhm.
cause for home, probable cause that they are home. But still, it's not that hard, man. The car's in the driveway, the lights are on, it's at night, it's a time
Yeah.
and day when they would be probably home. It's like 6 o'clock in the morning,
Mhm.
6 o'clock at night, shit like that. It's not hard, but that's what I teach, Zach. What do you think?
I think that's completely right. I just have a hard time saying that we can authorize entry into somebody's backyard with no belief the person is home. Um, yeah, it's not the same as walking into the house, but it's awfully darn close.
Yeah,
So yeah, Brandon, I think you need at least some reason to believe the person's home and that they live there
yeah.
uh, before you can set up your perimeter on the curtilage. On the curtilage.
Um, so Brandon says, would you be allowed to walk around the driveway to read the tags if it's not plain view? So they want to like kind of like see if the car matches the person. Look, first of all, do you think that do you think that that is an area open to the general public for a knock and talk that if you were walking up to the door, you would pass those tags?
I think if the answer is
Oh,
yes, he
no.
says no. Okay, he says no. Mm,
Well, I got some good news and some bad news. The good news, the bad news is you're playing with fire. I mean, it's intrusive, right? You are potentially violating their curtilage. You're in a space where if you agree it's curtilage, that's the first question. Some courts don't think so. Sometimes they think that there was a case where the car was parked in the side of the house and they didn't think it was curtilage. I totally disagree with it. Remember that case? I think we talked about it, Zach. The one with the undercover the auction police car where the guy had the red and blue the red and blue.
yes, yeah. I just don't know how that's not curtilage. I
Dude,
don't
that
understand
judge,
that.
man,
Yeah.
he still pisses me off on that one. But look, we can have a debate on that one. So, but the point is, if it is curtilage and you're looking at the car, I mean, how do you get away with that? I mean, where's the crew? Where's the consent? Where's the recognized exception? Where's the warrant?
Yeah.
And the second thing is, the good news is, if it does come back to him, and that gives you the reason to believe he is home, and you serve that warrant, I don't see a lot of bad stuff happening to you because now you have the judicial authority. It's a little bit tainted as far as how you got the information, but ultimately he cannot suppress his arrest. But what he can go after you for is some kind of, nuisance violation of his curtilage. Maybe you find something on him during the arrest and he wants to say the arrest itself is unlawful. I mean, who knows? You're playing with fire, but just be careful. I
Yeah.
wouldn't do it too much, but it probably won't have the most disastrous consequences if you should have at least a reason to believe it is his house. I think that'd be okay. I mean, but again, I'm not recommending
Yeah,
it
I
either way.
wouldn't go traipsing around the entire property, but
No, 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 I wouldn't do that. But just
yeah.
just be careful. And again, I would just probably try to more rely on what you see from the outside and what you know about this guy, and try to just really see if you actually have the reasonable suspicion or probable cause right there and then. It's not high standard. It's just a fair probability it's his house. It's a reason to believe he's currently home.
Yeah.
That's all.
Knock on a neighbor's door and ask them.
Exactly. Throw rocks at his window.
There you go.
Hey, Peter, man. Okay. um, all right. So this officer has a question. It's a cop in Henderson, Nevada. And oh, he's talking about touching trunks during traffic stops. So, Zach, I go back and forth on this. Like as far as like what these cops, let's just talk about a couple things. Okay, there's two touching trunks that I've seen. One is putting your fingerprints on the trunk, Did you ever do that as a cop when you're in the old
I
days?
did early in my career until I realized how silly that was.
So
I
yeah, it's like
stopped
kind
doing it.
of it's like a trooper thing, you know?
Yeah,
You know.
I was
And then
taught. But yeah.
so then putting the fingerprints on the trunk, and then the second thing is checking trunks to see if they're loose and there's somebody back there. The
Right.
first one is, do you think that putting your fingerprints on the trunk or on the back of the car or whatever is a search under the Fourth Amendment?
No, because you're lacking the intent to gather information, I think.
Well,
Um,
John Ween brings up a good point. He says, how is, and it's a very good argument because I said the exact same thing as you did. And he
mhm.
says, wait a minute. He says, Anthony, how is that any different than the chalk marks in Saginaw? Because at the time of the chalk marks, it provided no information. But they came back 2 hours later and saw that the chalk marks are still there. So Saginaw is your parking enforcement case where they put chalk marks on the, I know you know this, but for the
Yeah.
audience, the chalk marks were used by parking enforcement officers to check to see if they can were there for more than 2 hours. And I got to tell you, analytically, it seems like the same thing. The fingerprints aren't there for me now; they're there for me later. If
Mhm.
the guy assaults me and becomes my assailant, it helps prove that he was the vehicle.
Yeah. Interesting.
Yeah. And also he used that. He also said that, even like the GPS tracker in Jones, at the time of smacking the GPS tracker, was it giving coordinates right instantly right then and there? Probably not. So what happens when it's 15 minutes later? So, look, I didn't really believe they were searches at first, but I think he kind of convinced me with Saginaw that there could just be this argument that it's not you're still trying to look for information like either now or your intent is still to gather information at some point in time, I guess.
I'm gonna think more about that one. That's interesting.
No, yeah, it
Uh,
is kind of interesting. I'm not sold either way, but I am going to lean towards that it is a search just because it's a safer bet, and also it just makes sense to me that if the courts are saying that chalking is a search, then I guess fingerprints is a search. But the reason why I say probably just say yes because who cares? Who cares? The world keeps turning,
yeah.
even if it's a search. Um, are you really gonna? Is your assailant gonna go free because they have to suppress some fingerprints on the back of his trunk, right? No, you probably have tons of other evidence that he's your killer. You know what I'm saying? You got video, you got the smoking gun, you've got the fact that he ran from police inside the woods.
Right.
So who cares? I mean, I don't care. I just if the prosecutor wants to suppress it,
Well,
or the judge, let him suppress it.
the is it a search question is only the threshold question. Then is it a reasonable search? There's the
Mm.
argument that it's a reasonable warrantless search to touch. I don't
Well,
know.
no, well, actually, no. That's actually exactly the great segue to checking trunks because that is probably more relevant to that's more real because that's the one that's going to result in a suppression of evidence. Cop killers aren't going to get off because we touched their trunk. Okay, we'll just suppress that piece of evidence and just go on with our life, right?
Mhm.
And it's not going to be the fruit of the poisonous tree for the whole case, but it's the trunk because cops are going to check trunks. In fact, okay, I thought it happened, but I was thinking of something else. But cops are going to check a trunk, and it's going to have a loose latch, right? Because the cartel is not good about putting the rivets back and shit like that. They really need to do a better job, by the way. We'll talk about that later when we get hired as their consultants. But they're going to check a cop is going to check a trunk on an old Grand Prix, and it's going to pop open. There's going to be 20 kilos back there, right?
Or the dead body,
Now, huh?
or the dead body, like the North
Oh,
Dakota.
no, or crawl,
Oh,
right?
yeah.
So now, what do you think about that? What do you teach your cops on that?
I think that's a reasonable protective search. I think that would be covered under the Terry/long, rationale. It's a minimally intrusive. It's a lawful stop,
Yep.
and it's a minimally intrusive step. It's akin to ordering somebody to step out of a car,
Yep.
on like under MIMS. It's not the exact same thing, but I think just under Terry and Long, I think that would be a reasonable protective measure.
Yeah, I agree. I mean, especially because all you have to do is articulate it, right? If you're my judge, Zach, and I say, Judge Miller, in my training experience, a lot of these new cars, they have to have those pull tabs, right? They're
Yeah.
fluorescent.
Hmm.
And, it's much easier for somebody to be back there and they can hold the pull tab and that they can immediately open up the trunk. And, has it happened? Not to me, but I have heard of it happening, by the way. Somebody was back there with a gun on the pull tab. And
Hmm.
so it's a rare event, But, traffic stops, Your Honor, are inherently dangerous. We see that with Maryland versus Wilson, Pennsylvania versus Mims, all these Arizona versus Johnson, all these cases, right? Your Honor, it's just dangerous. My cop is just testing the truck to make sure that nobody's back there with a gun with the pull tab. I think you would buy that, Judge
I
Miller?
do, absolutely. Yes, my motion denied.
Good. And it's
Evidence.
also, just to on the topic, I've had this come up twice in the last week, is that, cops have been stopped some cars where the cop could not see through the back window tint. And the driver said that the windows didn't roll down. One driver said they didn't roll down, which is an indicator of trafficking because the window mechanism might be broken. And the other one is that he said that the tint was new. So the cop in both cases, basically unlocked the door. I'm sorry, the door to look back in the back seat to see if there's anybody back there.
Okay.
What say you, Judge Miller?
That's if we've given him the opportunity to roll down the window and that's not possible, it's reasonable for the officer to want to account for how many people are inside the car. That sounds like a reasonable, minimally intrusive step.
And also, bingo, I totally agree. I think the key there is give them an opportunity to do what you need them to do. And I think officers absolutely have the authority to know who's inside that car. Some cops that also want to make sure if people are back there for seatbelts, that might be a highway safety rationale too. Make sure people have their seatbelts on. But I think more, it's just a clear, crystal clear danger to officers if there's some people back there you have no idea are back there as you're doing your business at the B pillar, right?
I thought you were going to do the cell phone, the light, the video with the cell phone.
Yeah. Okay.
Same thing. Same thing.
Yeah. So you're putting your cell phone up to the tinted window, and the cameras will see through dark tint. The newer cameras will, right?
Yeah.
And is that a search?
If you touch the car, it is. If you physically touch the window, yeah. That under Jones, yeah.
Yeah. Now, if you hover over it, that's a little different. That's a little more challenging, right? Under privacy.
Yeah, probably don't have a reasonable expectation of privacy in that regard.
I think so.
You do have to touch it. And most of officers have told me you have to get awfully darn close to it or touch it.
One cop told me that he can do it by hovering, so he might know Jones, right?
Okay.
But it's like operation. It's like when operation you touch the sides. Like right when he touches it, he'd be like, he's like,
the Jones alarm goes off. Right?
We need a Jones alarm.
Right. Yep.
Right. Now you done messed up. You need to go back and play more operation because the tip of just touched the tint or the window. All right, guys. Look, we did a bang up job answering some questions. I think we got some really good questions and answers. Zach, thank you. We had a relatively quiet audience, but that's okay. If you have any questions before we leave, we'll answer them. But if not, we're going to call it a day. Any questions before we go? And if not, either way, did you enjoy this webinar? If you liked what we did today, if you appreciate our time that we're trying to help you, use the little heart, the love, right? Zach's time is important to him and his family. My time is important for me and my room actually, I don't have a lot of important time right now. I'm just glad that you guys are here because if not, I'll be watching, Friends. All right. For those who are watching online, thank you so much for joining us. I really appreciate you having here. Please share this video with your friends. Share it throughout the whole entire department. Download it. Include it in training. You can do whatever you want with it. You have our full permission. Don't even ask. Do whatever you want. Hell, sell our likeness. You know what I'm saying, Zach? Make a movie out of these podcasts. Until next time, my friends, you stay safe. Thank you again, Zach.
All right. See you guys later.